Reading the law. In the previous video we showed you how to find the law. In this video we will show you how to read and interpret the law that you find. Here's an example of a very simple piece of legislation. Let's work our way through this particular piece of legislation line by line. So the first line gives us the short title of the Act, the Radio License Fees Amendment Act of 2007. We're told that it's Act number 69, passed in the year 2007. Below that we're given the long title of the Act, an Act to amend the Radio License Fees Act of 1964 and for related purposes. The long title can be very useful because it often tells us what the purpose of the legislation is, and that can be useful in interpreting the legislation, which is a point that we'll discuss in more detail a little later in this video. The third line tells us that the legislation was assented to 28 May 2007. You'll recall from earlier topics that an important part of the process of passing legislation is the assent or the royal assent by the Crown representative. So here we're told that this particular piece of legislation received the assent of the Governor-General on 28 May 2007. Below that we have the enacting words. The Parliament of Australia enacts. So we know that this is federal legislation because the enacting legislature is the Parliament of Australia. And then there are simply three sections. So this is a very short piece of legislation. Legislation can in some cases go for hundreds and hundreds of sections, but this is a nice simple one. So section 1, the heading is short title, and sometimes the headings can be useful in helping us interpret the legislation. And then we're given the substance of the section. This act may be cited as the Radio License Fees Amendment Act 2007. So the first section gives us permission to use the short title when referring to this legislation. Section 2, the heading is commencement, and it tells us when this legislation actually commences. In other words, when people have to start obeying it. This act commences on the day after it receives the royal assent. So we know that this particular legislation came into effect on 29 May 2007. And then the third section, and final section of the Act, is headed Schedule. And it says, each act that is specified in a schedule to this Act is amended or repealed as set out in the applicable items in the schedule concerned, and any other item in a schedule to this Act has effect according to its terms. After section 3, we're given the actual schedule. Schedule 1 amendment, and then we're given one piece of legislation, the Radio License Fees Act 1964, and then we're told how this particular piece of legislation is amended or repealed. And we're told that subsection 4.1, definition of gross earnings, is amended because it says that after service, insert or services. So this piece of legislation simply amends an earlier act, the Radio License Fees Act of 1964, by inserting two extra words, or services, after the word service in subsection 4.1 of the original act. Now let's take a look at the other type of law, case law. We won't go through the details of the actual text there, but you can see that it's set out very differently. Where legislation tends to be broken into sections and subsections and is very structured, case law tends to be a continuous text. It's a narrative. Case law is, after all, the written reasons that a judge has given for their decision in a particular trial. Now these reasons can sometimes go for a page or two, sometimes they can go for hundreds of pages. Reading a case report can be very informative and educational, but it's important to note that not all of the case report is binding law. We actually draw a distinction between the ratio decidendi and the obiter dicta. The ratio decidendi is the smaller part of the written decision. Ratio decidendi is Latin for reason for the decision, and it's that part of the case report that sets out the legal principle upon which the decision was based. So in other words, it's the part of the written decision where the judge says, essentially, this is the legal rule that I have used to resolve this particular legal dispute. It's that part of the written decision that's binding precedent. It's that part that is the important part that other judges have to follow in future decisions. The rest of the written decision is mainly obiter dicta, which means saying by the way. This is the part that's educational, it's informative, it's usually worth reading. It includes things like the identification of the relevant evidence, the discussion of alternative legal principles, alternative decisions if the facts had been different, and the historical development of the legal principles used in reaching the final decision. But it's not binding precedent, and other judges are not obliged to follow this part of the legal decision. The challenge that we face when reading legislation, and to a lesser extent case law, is the fact that legal writing is often very difficult to read and interpret. Legal writing is notoriously difficult, often because it's long, complex, repetitive, badly organized, unnecessarily elaborate, and confusing. The challenge is also the fact that language is inherently uncertain. Particularly in the English language, many words have multiple meanings, and it's not always clear what a particular legal rule means. Judges, of course, have been wrestling with this dilemma for many, many years, and over the centuries they've developed a number of approaches, rules, principles, and assumptions that they use when they are required to read and interpret the law. And it's very useful for us to know about these approaches, rules, and presumptions because they can assist us when we have to read legislation and other types of legal text. So in the remainder of this video, we're going to go through 5 categories of approaches to statutory interpretation. We'll talk about the literal approach, the contextual approach, the purposive approach, some common law presumptions, and we'll finish up by very briefly looking at some statutory rules. So the first approach is the literal approach. And we should always begin by reading legislation as literally as we possibly can. According to the literal rule, we should always begin by reading a text literally with words and phrases given their ordinary and natural meanings. This can be a challenging way to read text because usually when we read a new piece of text, we try and work out what it is that the author meant or what they intended to say. But when we read something literally, we focus upon the actual words used and give each word its ordinary, natural meaning. For example, in the case of Fisher and Bell, a shopkeeper was charged with breaching this particular rule. Any person who sells, lends, or gives a flick knife to any other person commits an offence. The facts of the case were that this shopkeeper had for sale in his shop window a flick knife. However, when the matter went to court, his lawyer successfully argued that he had not breached the rule. Read the rule literally. Any person who sells, lends, or gives a flick knife to any other person commits an offence. The lawyer argued that the lawyer had not actually sold a flick knife. The flick knife was for sale, but it had not actually been sold, and so the shopkeeper had not committed the offence. The court agreed with this literal interpretation of the rule, and the shopkeeper was found not guilty. There are limits to how literal we can be when reading legal rules, and there is in fact a golden rule that says that if reading a text literally leads to an absurd result, we should modify the literal meaning so as to avoid the absurdity. In the case of Leah Knapp from 1967, a motorist was involved in a car accident, but instead of staying at the scene of the accident and providing their personal details to the other parties involved in the accident, they fled the scene. And they were charged with breaching this particular rule. If in any case, owing to the presence of a motor vehicle on the road, an accident occurs whereby damage is caused to a vehicle other than the motor vehicle, the driver of the motor car shall stop. The motorist's lawyer argued that the motorist had not actually breached this rule because the motorist had stopped at the scene of the accident. They had stopped momentarily when their car collided with the other car. The court decided that this was an interpretation of the legislation that was too literal. And using the golden rule, they decided that the word stop at the end of this rule did not mean simply stop momentarily, but stop and stay there. The literal approach to interpreting legislation and other forms of text is the traditional approach, and it's an approach that most lawyers and judges will always begin with. But in more recent years, courts have tended to favour a more contextual approach to the interpretation of statutory provisions. According to this approach, rather than interpret the words used in an act individually and in isolation from each other, a court should take into account the various contexts of those words. There are a number of different contexts that a court can refer to when interpreting legislation. One is the immediate context, and according to the context rule, the meaning of a word or phrase in legislation is to be derived from its immediate context. In the Crown against Harris from 1836, a prisoner who would have been involved in a fight in prison and had bitten the nose off of another prisoner was charged with breaching this particular rule. If any person unlawfully and maliciously shall shoot at any person by drawing a trigger or in any other manner attempt to discharge any kind of loaded arms at any person, or shall unlawfully and maliciously stab, cut, or wound any person with intent in any of the cases aforesaid to maim, disfigure, or disable such person, or to do some other grievous bodily harm to such person, they shall have committed an offence. Had Harris breached this particular rule? If we interpret this rule literally, Harris had not shot at any person, they had not stabbed the person, and arguably they had not cut the person, but they had wounded the person. They had bitten their nose off. So in a literal reading of this rule, Harris had breached the rule. But if we consider the context of the word wound, which the court did in this case, and consider the first part of the section, which focuses upon injuries caused by the use of weapons such as guns or knives, then a contextual interpretation of the word wound means that wound does not mean literally any type of wound, but the type of wound that is caused by the use of a weapon on another person. The court decided that teeth did not count as a weapon, and that therefore Harris had not actually wounded the other prisoner within the meaning of this particular section. Another example of taking into account the context of the words used in a particular rule is the class rule, where two or more specific words are followed by general words. The general words are interpreted to accord with the class created by the specific words. This rule is best illustrated using an example. Imagine that there is a rule that says that students are not permitted to consume beer, wine, spirits, or other drinks in the classroom. Are students allowed to drink water in the classroom? If we interpret this rule literally, then water is not beer, water is not wine, water is not spirits, but water is another drink, so this rule would include water. But the class rule tells us that where two or more specific words are followed by general words, the general words are not interpreted literally, but are limited to the class created by the specific words. So here we have three specific words: beer, wine, spirits, and the general words are other drinks. Beer, wine, spirits create a class, alcoholic drinks. And so other drinks does not mean literally any other drink, but other alcoholic drinks. So applying the class rule, students are allowed to drink water in the classroom.